Hello, everyone, and welcome to the National Constitution Center. Happy Friday. Happy end of law week. We are so excited that you're all tuning in today. We have a fabulous discussion. Clark Neily is here to talk about the Fourth Amendment, and we are very excited to get started. We've got about 5 minutes until go time, so make sure that you send those questions and comments in the chat. We would love to hear from you. Feel free to test out that chat feature. Hi, Ryan. So good to see you all. So happy that you're all here. I'm very excited to be back and with you all today. So we've got about 5 minutes until go time, and then we are ready to go. Oh, greetings, Mr. Bauer students from Central Virginia. Very excited that you're here. Very, very pumped. This is going to be a good one. Students we love talking about the Fourth Amendment. We love talking about privacy, all that good stuff, search and seizure. A lot of fun topics to go hand in hand today. Who else do we have here? Tell us where you're tuning in from. We love to see that. Let us know where in the world you are. I'm here in sunny California. We have friends here from Virginia, some friends here from Michigan. Super exciting. Let us know who is here and who's watching. San Antonio, welcome. Very exciting. Hello from Mr. Hobgood's class in North Carolina. Hello. Very awesome. We've got friends from Florida, friends from Oklahoma. Andrew from New York, welcome. Very excited to see you all here. This is awesome. Love that you're all tuning in today for a fabulous Friday to talk about the Fourth Amendment. Clark Neily is an awesome speaker, so we are super lucky to have him here to answer all of our questions, everything that we want to know about the Fourth Amendment. So make sure you send those to me in the chat. I'll make sure to get them to Curry. She'll be on stage with Clark Neily. And then Jeffrey Rosen will be joining us too momentarily. So it's going to be a good one, friends. I'm very excited that you're all here. Yes, Clark Neily does have the best Twitter handle @ConLawWarrior. So I'm going to put feel free to follow him. If you have Twitter friends, definitely pop on Twitter and follow Clark Neily. He has an amazing Twitter handle and he has some good tweets too. All right, we've got about 3 minutes until go time. Very excited to see you all. It's been so long since I've seen some of you in class. I'm so excited to be back, so excited to see all of you. This is going to be a fun one. And remember, if you have questions, put them in the chat, put them in the Q&A box. We'll make sure to get them to Curry so that she can ask Clark all of your questions. It's going to be a good one. As you can see, we're streaming live from the Constitution Center. We've got folks at the museum in Philadelphia who are going to be watching this discussion live in person. And then all of you are as well. You're here today too to watch this conversation. So we've got the best of both worlds here, a little hybrid class for all of us. Gives us flashbacks to teaching in 2020 and 21, huh? Sam, great question. I'll make sure that I send that to Curry and she can ask Clark. Awesome. Yeah, friends, send me your questions. I'm happy to get them to Curry so that she can ask Clark and he can kind of dive into more content with all of us. It's going to be a good one. All right, 2 minutes until go time. I guess I can ask all of you. Does anybody have a favorite Fourth Amendment Supreme Court case? Let me know. I like to hear everyone's answers. Let me know what you're interested in.
Streaming live from the National Constitution Center. So just give us about 5 minutes and get all of your questions ready. The team is going to bring them all in the chat and then share them with us on stage as they come through. So thank you very much for being here. 5 minutes, and we will see you back here at the NCC. Sounds so loud.
All right, friends, we've got plenty of time for more questions, or you can just tell me how your week's been going. How did we all celebrate Law Day this week? Monday, May 1st was Law Day, and we had a lot of fun talking about principles of the American Revolution, foundations of American democracy, all of that good stuff. So a fabulous week, really, to talk about the Fourth Amendment. And congratulations to all of you who took the AP Gov exam to celebrate Law Day. What a fun way to celebrate. There really is no better way, is there? Yes, and Law Day will have to be marked on your calendar from this day forth. Absolutely. And all my friends who took the AP exams, we feeling good? We feeling confident? I know that you knocked it out of the park. I'm sure you all aced it. 5s all around. Amazing work. Very exciting stuff. I love it. Mr. Rowanka's class, the students crushed the last FRQs. Excellent. We love to hear that. Fabulous, fabulous work. All right, we are going to get started, friends, in just a minute.
Hi, Curry. Hi, everyone.
Hi, Jeff. We're going to go ahead and spotlight you and make sure that Curry and Clark can hear you in the auditorium, and then we'll be good to go.
Wonderful.
All right, friends, we've got about a minute until go time, and then we're going to talk all about the Fourth Amendment. We have a fabulous scholar here today. It is going to be a really fun session. So get those questions ready, get those, those brains turning. We want to talk all about the Fourth Amendment, and it's going to be a great way to wrap up Law Week. All right, let me make sure that Curry is added. Mr. Clark, Neily, and Curry are here.
When do you wear a tie anymore?
The balance of tie, no tie.
Because,
Perfect.
If you're the only one on a panel wearing a tie, it sort of stands out where you're like,
oh, get off though, right?
Excuse me, what?
Like, that's easy. Like,
you can, but
yeah.
You look like I wear a different shirt when I'm not wearing a tie,
Got it. Hi, everybody. As you come on in, you can sit close. We're going to start in just a couple minutes, so get yourself settled, and it's good. For a lot, what I was going to say. Can we hear Jeff?
Hi, I can hear you guys. How are you?
Okay. Jeff was like, can you hear me? Okay. Okay, everyone. Are we officially ready to get started? So I'll look at my team in the back of the room, thumbs up, awesome. And then I'll look at all of our viewers across the country, thumbs up, you're all ready to get started too. And then all of our lovely people here at the National Constitution Center in Philadelphia, you all ready as well? Good. Thank you very much. My name is Curry Sautner. I'm the Chief Learning Officer here at the National Constitution Center, and welcome to class. This is one of our favorite things that we do at the Constitution Center. We have monthly conversations for all the country to join in, from students in their classroom to adults at the Constitution Center and students at the Constitution Center. And we are here to talk together all about the Fourth Amendment. As we go through class, if you have questions, those of you online, you can put it in the chat and our team is going to text them to me. So when I'm looking at my phone, I'm pulling up your questions. For those of you in the room at the end, we will definitely have a mic going around so you can ask your questions directly, but it'll be very fun. It will be recorded and we're so glad you're all here with us. Now, thank goodness I am not alone doing this work. I am here with two amazing scholars. Number one, Jeff Rosen, our president and CEO at the National Constitution Center, is with us. Hi, Jeff. Can you hear everything okay?
I sure can. Hi, Curry, and hi, Clark. It is so great to see everyone.
Hey, Jeff.
And then our big VIP star of the day is Clark Neily. We're so excited to have you here, Clark. He's one of our favorite scholars. We get to talk to him about so many important things. And he is, let me get your title correct, Vice President of Legal Studies at the Cato Institute. We talked to him about the Fourth Amendment. We talked to him about the Second Amendment. But what we really like about Clark is he's a fantastic teacher, and he really helps us unpack not just the words behind those amendments, but also the understanding of how this has changed over time and the cases that really make this such a powerful thing to learn. Because when we talk about the cases, we talk about the people, and that's a really interesting way to learn constitutional law. So let's kick this off and get started. Jeff, I'm going to turn it over to you first. You can get us rolling. And what are some questions you have for Clark?
Well, why don't we start with the cases and the people? And Clark, one of the big cases that sparked the Fourth Amendment, as we all know, was the case of John Wilkes in England. He was the guy who criticized King George. He wrote some anonymous pamphlets. The king was really upset. He wanted to find out who wrote the pamphlets, and he issued a general warrant authorizing the search of lots of people's houses. Many people had their privacy invaded, and finally they located John Wilkes, and he was tried, and he won a big verdict, £1,000, and that came to stand for the proposition that you can't invade someone's home and violate their private property rights with unreasonable searches and general warrants. You got to particularly specify the place to be searched, the thing to be seized, and that led to the language of the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So that was my quick summary. You've written so powerfully about this historic core of the Fourth Amendment. Tell us about the significance of the Wilkes case, which helped to spark the American Revolution.
Yeah, well, so I think the sort of the underlying essence of all of this that we can all really hopefully still connect with is the idea that you want to have a place in your life where people can't just barge in, especially people who claim to have the authority to do that. Even if it's the King of England looking for seditious pamphlets or pamphleteers, and over time, what has emerged is this idea that the sovereign, the king, the president, whoever it might be, should not be the ultimate arbiter of when they get to barge in on your life and just root around looking for whatever it is they're interested in. And so, over the span of time, that's something that's remained consistent. It's a sort of a human impulse that's very understandable. None of us is ever going to meet, obviously, John Wilkes. We don't really even have a really clear understanding of what was going on back then, but that's a thing that hasn't changed. Is the government will, from time to time, have a desire to involve itself in your life, to go snooping around in your persons or your houses, your effects, your papers, and there has to be some framework that enables us to decide when it's appropriate for the government to do that and when it's not. And that framework in our country is provided by the text of the Fourth Amendment, which is what we're obviously here to discuss. And it's really, in some ways, one of the most practical amendments because it's sort of the thing that stands between you and a government that might wish to just, as Jeff mentioned, arbitrarily sort of go and look wherever it wants to. And there was a time when these sort of general warrants would issue from a court that just was a blank slate. Yeah, go look for anything you want, wherever you want. The Fourth Amendment doesn't permit that. And we'll talk more about what the Fourth Amendment sort of puts inbounds and out of bounds in terms of when the government can come and look and root around in your stuff.
And I appreciate that you're adding in there the government. So it's a framework. The Fourth Amendment sets up that framework for us to understand when the government can and cannot do that. So because really clearly, and I'm sure you guys are really obvious about this, because your parents can. There's other things around this. When we look at the Constitution, we're talking about the power and the limits on the government. So Jeff, back to you to keep going with our case storytelling.
Well, let's fast forward to today. And Christian Turnquist asked a great question. Has there been an exact standard set for search and seizures in modern technology? What counts as privacy when on the internet? So the case I want to ask you about, Clark, is US v. Jones. That was the case involving the government putting a global positioning system device on the bottom of a guy's car and tracking his movements 24/7 for a month. And he sued. He said, that's an unreasonable search. You can't reconstruct my movements for a month without a warrant. And the court ultimately agreed, although they disagreed about the reasoning. And five justices said, because there was a violation of private property when the police walked onto the guy's driveway and put the GPS device on the bottom of his car, it was like John Wilkes having his house broken into and his privacy was invaded. But there's a separate question about what if there hadn't been a physical private property invasion and they'd simply tracked his movements by reconstructing his cell phone records without a property-based trespass, and that question arose in future cases. So tell us about that significance of the case and where the law stands right now about whether or not the police can reconstruct your movements using digital data.
Yeah, this is an absolutely fascinating question, right? Because technology marches on. The government has the ability to surveil us in ways that could never have been conceived at the founding. And so one of the real challenges with the Fourth Amendment is making sure that it keeps up with the times. Another challenge, of course, is that it has this unabashedly subjective language. It prevents unreasonable searches. Well, what does that mean? And is it, different people could have different understandings of what's reasonable. In the Fourth Amendment, the touchstone in terms of the way the courts have interpreted it, is that a warrantless search, in other words, a search that's initiated by the government without first going to a judge and making out a case for why you should be able to search in this particular place for this particular thing, that's what you do to get a warrant. In the Jones case, they had suspicion that Mr. Jones was engaged in some criminal activity, I believe drug-related criminal activity, but they didn't go get a warrant. They just decided, you know what, we're just going to put a GPS tracking device on his car. So they went onto his private property, attached that to his car without a warrant, and then were able to track his movements, or at least when he was in his car, for over a month. So the touchstone again is what is reasonable, what is unreasonable. Now, the people who wrote the Fourth Amendment could never have imagined a technology that would enable you to track somebody from a remote location, the way you can do with GPS. And so what the justices had to do was really try to have this kind of updated framework. And I think one of the most compelling moments in the case was during the oral argument when one of the justices, and I think it may have been John Roberts, basically asked the government lawyer point blank, so is it your position that you could put a GPS tracking device on one of our cars without a warrant? And the government lawyer basically had to admit, yes, but we wouldn't, And that, I think, makes it very personal. You can, hopefully most of you can feel kind of viscerally how you would feel about that. Remember that this would be done in secret with no prior approval from a court, just on the mere suspicion of a member of law enforcement. Boom, they put an AirTag, or a GPS tracking device on your car, and now they know everywhere you go. Now, maybe if you're having a slow week, that's not a really big deal, but you can, I think all of us can well imagine some places that you might wish to visit that you wouldn't necessarily want the government to know that you had gone to. And so that was really the essence of the Jones case. And I think the unreasonableness of the government conduct in that case, which again involved attaching a tracking device to a private vehicle and being able to see everywhere it goes for a month, is underscored by the fact that it was a unanimous decision. They didn't all 9 justices agreed that it was a violation of the Fourth Amendment. They embraced different rationales for that. But it is somewhat unusual for all 9 justices to agree that a particular Fourth Amendment case, presents an unreasonable search or an unreasonable seizure. And again, I think that underscores just, sort of how far out over its skis the government was in that case in trying to characterize this warrantless use of a GPS tracking device as reasonable within the Fourth Amendment. And the court said, no, it's not.
And I think it's really powerful to think about how much technology has just changed in the last 10 years with the fact that you can AirTag anybody in a second. I have right now AirTag my cat because it keeps getting lost, and it's amazingly accurate in finding things and seeing exactly where it goes. Now, a question around that, number one, for all of our students to understand. So why does the court need to approve? How does that help the system of checks and balances for the court to be able to approve a law enforcement's request to have a warrant?
Yeah. So, I mean, I think we've probably all experienced this sometimes when you think you know a thing to be true, but then when you have to explain to somebody why you know that thing to be true, sometimes you can do it and you're like, yep, I'm making a really persuasive case. And other times you realize like, oh, no, actually, that was just a hunch. And the Fourth Amendment is designed in part to ensure that members of law enforcement and other government officials can't root around in your private life on the basis of a mere hunch. Just it's the way you look, or, people like you aren't usually driving that kind of a car, or whatever it might be. And instead, they have to go to a neutral third party, somebody who's not part of the investigation. I mean, think about it. If you're the police officer who's doing the investigation, your job kind of depends on whether you make an arrest. I mean, maybe not literally, but you're going to get evaluated on that. So requiring police and other government officials to have to go in front of a judge who's not involved in the case, their career doesn't depend on how it turns out, and just make a case. They don't have to make a case beyond a reasonable doubt. That comes later if the case goes to trial. They simply have to establish probable cause to believe that the thing they're looking for will be in the place that they want to go get the warrant to search for. And probable cause is it's a pretty malleable standard, but it essentially means, it doesn't mean like more probable than not. It just means that you can articulate a rational reason to believe why the thing will be there, or why the person engaged in whatever conduct it is. And you just have to make that case to a neutral magistrate who will then decide whether you establish probable cause and whether the search that you have asked for permission to perform is sufficiently focused that it doesn't turn into one of these general searches that Jeff mentioned earlier. So you're not going to be able to go, for example, like search an entire warehouse unless you can articulate why you need to do that. They'd rather you say, look, there's a particular drawer within the warehouse where the thing is going to be, and that's where we're going to look.
And this is perfect because I'm going to guess what Jeff's next case question is, but I'll keep it in my head and see if I get it right. When we talk about searches and where you can search, Jeff, I'm guessing that's the next case that you're going to bring up.
Well, I was thinking of the Carpenter case.
Yay, we're right.
Yeah,
okay, so the Carpenter case, where can you search? Is it your trash can or is it your cell phone? And what do you do with it? So over to you, Jeff.
Absolutely. So Carpenter is just a variation on Jones, but it doesn't involve a trespass. Carpenter, they're not putting a GPS device on the bottom of the guy's car. They're searching his cell phone records. And as we all know, all of our movements are stored on third-party servers that are run by our cell phone companies, Verizon or Comcast or whatever it is. And the police can get those records without physically intruding into our house. They just ask Comcast or Verizon. So that's the question. Verizon in Carpenter, can you reconstruct a guy's movements just pinging his cell phone without a trespass? And a majority of the court, led by John Roberts, says yes, because we can learn so much about someone if we reconstruct their movements. It's as if we're breaking into his house and reading his private diaries, as in the days of John Wilkes, even without a physical trespass. And the dissenting justices says, no, you got to have evidence of a physical trespass. And then there's a really interesting debate where Justice Gorsuch says, well, maybe they're violating his property rights because they're breaking the terms of service agreements, and he had some kind of expectation that his data would be respected, which they violated. But Clark, I really want to ask you about this case because the Cato Institute, where you lead the legal studies department, has done such heroic work in defending rights of free speech, of private property and individual liberty. You've argued for a private property-based approach to the Fourth Amendment and have filed briefs in cases like Sorensen versus Massachusetts, urging for a property-based approach. How would you come down in this tough Carpenter case, and would you require a physical trespass, or do you agree with the majority that the Fourth Amendment was violated even without it?
Yeah, no, I appreciate that, Jeff, and thanks for those kind words. I mean, so the Cato Institute, where I work, we're unabashedly libertarian, and one of the things we care about is property rights. And one of the aspects of property ownership that we don't always necessarily think about, particularly when it comes to kind of intangible property, like data, for example, is the right to exclude other people. That's sort of much easier to conceptualize if you're thinking about maybe your home. Perhaps you have a nice backyard with a fence around it, and you don't want just anybody coming in there and sort of, helping themselves to your swing set or whatever. But you also have a right to exclude. So hopefully it's pretty intuitive that an aspect of your property ownership is the ability to exclude somebody from your yard if you don't want them in there. But you also have the ability to exclude people from things like the information that your phone generates as you go about your day. I would guess that most of you in the audience have one of these, and it's probably with you most everywhere you go. And that's a lot of information for a stranger to be able to acquire about you, your life, and what you do, who you hang out with, what kinds of facilities you may have visited in a given day. And we can think about the data that your cell phone basically produces as you go around about your day, because your cell phone is in more or less constant communication with cell towers, and you can get a pretty high degree of precision, particularly in urban areas like this, about exactly where somebody has been. And the argument that we made, my colleagues and I at Cato made in the brief, and that was I think featured in the Neil Gorsuch dissent, is that a good way to think about this is that data is property, and you have a right to exclude people, including law enforcement, from that data. You have a contractual agreement with a cell service provider that they will handle that data in a particular way. And we get into this in the brief. We actually provided a link to the I think it was I forget it was Comcast or who it was, but T-Mobile, I think, actually, their terms of service. And they make very clear that there are certain things that they may do with your data and things they may not do with your data. For example, selling it, to other interested parties. So that was the essence of the argument. I don't want to get too far down that rabbit hole. I'll pull back and instead say this. What the court has tried to do over the years is come up with different ways of conceptualizing what it means for a search to be unreasonable. And there's no, I think, single kind of most satisfactory way to do that. The different frameworks that they've come up with seem more satisfying in some contexts than others. But I think in this context, and when I say this context, I mean the context of where the government purports to have the ability to just go to your cell phone carrier and say, hey, you know what? Those aren't your records. That's not your data. That belongs to the cell phone company, and we just asked them for it. And it's none of your business that they decided to turn it over to us. I think that the property approach works really well there, because you actually do have a contractual agreement with your cell service provider, and they have told you that there are certain things they'll do with that data and certain things they will not do with that data. And you can probably tell this is creeping into the tone of my voice. I just don't think the government really has any business coming along and saying, we're not a party to that agreement, but we're going to treat it as if it's meaningless, and just treat it as if all of this data that your cell phone has generated basically passively as you've gone about your day is just free for the taking. And I don't think that's, now I'm going to get really, sort of touchy-feely, but I think what really moved the 5 justices who struck down or characterized the search in Carpenter as unreasonable is that you just don't want to live in that world, do you? You really don't want to live in that world where the government can just go to any service provider, whether it's, whoever's got your browser history information, right? Or your cell phone records or whatever else information trail you're leaving out there. And the government can just come along and say, hey, we're just going to vacuum that up. We just want to know everything we can about this person. I don't want to live in that world. You don't want to live in that world. And I think the justices don't want to live in that world, at least 5 of them. And that's why they said, just get a warrant. It's not that big a deal. They had really good suspicion, by the way, of this guy Carpenter. He was definitely part of a robbery ring, and one of his cohorts have been arrested and identified him. They could have gotten a warrant. They just didn't bother. Well, that's not good enough.
Interesting. So a question that Anne had online was, when we think about this, are there anything that the companies or the technology infrastructure itself can do to kind of make people more anonymous, maybe? But also, we're not just talking about cell phone data and where you go. Like Ancestry, the DNA companies are part of it. There's a lot of data collection that's outside of just my messages and my texts.
Right. So that's a very technical question that I'm frankly not qualified to answer. But I think that tech companies are going to be increasingly mindful of this, and I would like to see them make it, maybe a kind of a way for them to differentiate themselves. Because I will tell you, if a cell phone company had a marketing campaign where they said, "We are the most protective of your data," that would be appealing to me. And I'm not even I'm a libertarian, but I'm not that kind of libertarian. But I just, I think like anybody else, I really don't want random strangers, including random strangers who happen to wear a badge, to have access to my whatever kind of personal information I generate as I go about my life. And I think I could definitely envision a world in which purveyors of services that necessarily end up sort of holding on to that kind of data that you have generated in the course of sort of your business relationship reassuring you that they will be as protective of that information as it is possible to be would be very appealing, and hopefully we'll see more of that. Now, let me emphasize again, I really think the dissent gave short shrift to the terms of service that were in those contracts, because I think, frankly, that T-Mobile and other carriers had really gone a considerable distance to emphasize that we hold this information, but fundamentally it's yours also. We have a kind of joint property ownership in this interest, and I think that's enough, or should be enough, to exclude the government unless they go and get a warrant, so that they can then have this, the warrant grants them that ability to access something that normally would be none of their business. And again, I don't want to sound like a broken record. They had enough probable cause to have gotten that warrant, and they should have. What they were trying to do was they wanted to have a lower standard so that they just wouldn't have to bother with it kind of, ever, whenever they wanted to go and get cell site location information. So I really applaud the Supreme Court for coming to, I think was obviously the right decision in that case. And I think it would have really been a disaster if, if the dissent had prevailed and the rule was that the government can just go and grab, basically any electronic information that you generate that happens to be in the possession of your, sort of the provider of that service. That's a terrible place to live.
Real quick follow-up questions, and I'll ping it back to Jeff after these two. So one, for all of our students, can you explain what a libertarian is? Just so they understand like that framing. I was like, oh, wait, we should probably define that. And two, Donna pointed out online that maybe we should read the service agreements, and I know, Jeff, you've talked about this too. I tried. They're really long and really even if you zoom in, it's a lot. That's a lot of not saying we don't have a responsibility to read what we sign, but you might need some help on that. And is that fair to say, okay, I'm getting a phone and now I have to be able to read this 80,000 page document?
Yeah, great questions. I'm not even sure what a libertarian is anymore. I know there are some who I really disagree with, but for me, it just means that I place a lot of importance on personal autonomy. I think that people should have sort of a maximum ability to decide how to live their lives and to create value in their lives and to be the kind of person that they want to be. I'm not an anarchist, which means no government whatsoever. There is a legitimate role for government, but in my mind, it's narrow. And really, the only legitimate function of government is to essentially enforce the rules of civil society, so that you don't have to be out, sort of like fighting off barbarians at the gate and so forth. But anyway, so we put a lot of emphasis on personal autonomy and requiring the government to have a very strong justification when it tries to control you or involve itself in your life. That's all I mean by it. Remind me your second question, because
second question is how in a short term, how hard is it for the average person to read and understand the terms of agreement?
Yeah, look, I mean, fortunately, I don't rent cars as much as I used to, because now there's Uber. But when I was younger and I traveled a lot for work, I'd rent cars. I don't think I've never read a car rental agreement as far as I know. Some of you have probably signed up to get a credit card because you want to get those bonus miles or whatever. I don't know what's in the credit card agreement. And so I don't want to go too far down that rabbit hole either. But generally speaking, those agreements are binding, even if you have not read the whole thing. They're supposed to not contain what are called unconscionable terms, like, oh, by the way, you also signed over your firstborn. That's not going to be enforced. But it turns out that even if you haven't read it, there can be some really important stuff in those agreements. And again, one of those things is, how is this company that's going to come into possession of some very private information about your life, whether it's your browser history or your cell site location information, how are they going to handle that, right? Are they going to sell it to people who might be able to monetize it? Are they going to share it with any Tom, Dick, or Harry that shows up and asks to see it, right? And so I think it's good that those agreements address those questions, even if the average consumer will not read it. It is still binding, and that's good.
Got it. Great. Jeff, I'll turn it back to you. And then we have a few more 1,000 questions coming in with the kids.
Absolutely. Why don't we just start running through some of those great questions? Linda asks if there's an uncomplicated Supreme Court case we'd recommend for younger middle school students when discussing the Fourth Amendment. I guess I was thinking of the TLO case, that case where the 14-year-old girl in a New Jersey high school had her backpack searched because the teacher suspected her of smoking cigarettes. They found some rolling paper in there, and then they looked harder and found that she was smoking marijuana, and she was disciplined for it. And they said, she said, you can't just search my backpack without some higher standard. And the Supreme Court said, you don't need probable cause to search a backpack. Reasonable suspicion is enough, because kids have a lower expectation of privacy in their backpacks. Clark, that was the case I thought of. How did I do summarizing that? And do you have any other simple cases that can teach the Fourth Amendment to middle school students?
Yeah, no, you did a fantastic job summarizing it. I just read that case actually on the train on the way up from DC. For those of you who are in school, or if you have kids in school, it's a challenging environment, right? Because especially in this day and age, I think we're all acutely aware of safety issues in school, of the need for school officials to be able to maintain order in the school, and but it's also the case that kids are human beings too. They're people, and they have legitimate privacy interests, just like the rest of us do. Now, the courts have held, I think correctly, that to some extent those privacy interests have to be not minimized exactly, but we have to recognize that there is some tension between the legitimate privacy interests that children in school have with the institutional interests of the school and keeping them safe and keeping order so that people can learn and so forth and so on. And so in this TLO case from 1985, what the court said in effect was that we're not going to require as high a showing of probable cause that we would, for example, maybe in a workplace before the government can look in your locker or search your car to see if you're taking anything home from the employer that you shouldn't have. That would have to be probable cause, and we've talked about what that is. Reasonable suspicion, about the only thing I can tell you about is that it is somewhat lower than probable cause and higher than a hunch, and good luck trying to define it more than that. But essentially, what the teachers would have to articulate in order to search a student's locker or their backpack, or even look under their clothes, would be a non-frivolous, non-speculative reason to believe that they might find something that the student shouldn't have in school. And that would probably be, like just another student saying, yeah, I saw him put a, well, God forbid, a gun or, some drugs or something under their sweater. That would certainly suffice, whereas it might not rise to the level of probable cause. Well, actually, that would be probable cause. So whatever reasonable suspicion is, it's somewhere between probable cause and a hunch. And what the Supreme Court has held is that the unique setting of a government-run public school should give teachers, principals, other administrators, even though they are agents of the government, since it's a public school, greater leeway to perform a search in order to protect the safety of the students and maintain order in the school, while still recognizing that those students do have legitimate privacy interests. It's a very, very difficult area. There's not a great deal of case law on it. I suspect that that a lot of this is being done on an ad hoc basis by teachers, and you're probably not seeing students file lawsuits every single time their Fourth Amendment rights are violated. Whether they should is a separate question.
So another question on that same front, and kind of the middle school level, it's a great question from Sam Doe, is the right to privacy. How does it change from your house to your car to your backpack? And does that change when things are in movement?
Sure does.
Or things, yeah. So yeah. How do people really measure that? And how we ask a lot of questions is, can they look there? Can they do that with our middle school students? And it changes where you are. Yeah. Airport could be very, very different. So can you kind of give us, how should students measure the expectation of privacy?
Yeah, so it's a great question, and the short answer is that yes, I don't know, you might think of it as like the footprint of the Fourth Amendment, or how protective is it in any given setting? It does change. The Supreme Court has held that it is probably at its most protective in your home, and so when you look at Fourth Amendment cases involving searches of homes, there's going to be a robust protection. The court is going to be pretty vigilant about saying, man, you better have a good reason to be getting inside that house, and we're not going to be, very flexible on, omitting the warrant requirement and so forth. But interestingly enough, the moment you step outside your home and get in your car, the Fourth Amendment almost disappears. In fact, there's actually something called the automobile exception to the Fourth Amendment, and I don't necessarily agree with it, but the rationale is that because cars are, mobile, so easy to, you get pulled over and you can drive away, you can try to hide the evidence by, outrunning the police or whatever, that generally speaking, as long as a police officer has probable cause to believe that if they search your car, they'll find something, they don't need to get a warrant, which they normally would. I mean, probable cause is not a sufficient basis to search somebody's home. You still have to get a warrant unless some other exception applies. But if the police officer, for example, pulls you over for, unsignaled lane change or something like that, and smells the odor of burning marijuana, which apparently is a big thing. There's a lot of cases where they smell it. I'm not always sure that was there, but that would be a sufficient basis, at least in a state where marijuana is still illegal, to search the car for drugs, or if they see, you know, a weapon, for example, in plain view. Fourth Amendment doesn't really exist very much in your car. Public school, we've already talked about that. Airport, good luck finding a trace of the Fourth Amendment in the airport. It's just not there. And, you know, look, I'm not going to get up on my soapbox about that. We all understand why the government's interests in searching people and containers that come into an airport is really high. But so good question. Yes, the Fourth Amendment, the how protective the Fourth Amendment is definitely varies by where you are.
Jeff, I'm going to ping it over to you for another student question, and then I'm going to go to you all in the room next. I haven't forgotten you.
Sam asks a good question. Does the exclusionary rule attach to the illegality of the search of the person whose rights were violated? Sam, my sense is that it attaches to the illegality of the search. In other words, you know, I can argue that the marijuana should be excluded if I'm the girl in the TLO case, but that only helps me if I'm actually disciplined in some way. Say I'm an innocent person like John Wilkes, whose desk drawers are searched and nothing happens to me, then the exclusionary rule doesn't help me at all. There's nothing I can do. In the old days, I could have filed a suit for trespass, saying the government, you know, trespassed in my home. But if I'm only relying on the exclusionary rule, some have argued that it protects the guilty but not the innocent. Clark, how did I do on that? Is that actually correct?
Yeah, Jeff, I'd never say you're incorrect. I would flee the room if I even thought it, but no.
No, I might be.
So, well, here's what this is fascinating, and believe it or not, it does come up. And it comes up in a setting where, for example, let's say I'm visiting a friend at their home, or maybe, you know, in a hotel room. I go, you know, we're on a business trip, and I go hang out with a friend who's got a hotel room or something like that. The ability to assert the Fourth Amendment actually depends to some extent on the possessory interest of the person asserting it. So I'll give you an example that came up in an actual case. Imagine that I go and rent a car, right? And maybe Carrie and I are on a business trip together, and without asking me, she just grabs the keys and drives the car to you know, the liquor store or something like that, right? And a police officer stops the car, performs an illegal search, and, you know, finds something belonging to her that she shouldn't have. She actually does not have a Fourth Amendment right to assert in that setting, because she does not have a valid possessory interest in that car. And the same thing, for example, if someone, you know, she was just let herself into my hotel room. This actually happened to me one time. I was a Russian major as an undergrad, and I went to Irkutsk, which is in Siberia, and I came back from a dinner. There were like 10 Russians in my hotel room having a party, totally unbeknownst to me. So none of them would have had the ability to assert a Fourth Amendment claim if the police had come and searched that room, if this had happened in America. And the case that I'm talking about, I can't remember the name of it. It came up about 5 years ago. It was a kind of a gray area, because this woman rented a car, and then her boyfriend was driving it with permission. And when he would, the car was illegally searched, he said, "Hey, you know, I didn't rent the car and my name is not on the paperwork, but she said I could drive it, which means I had a sufficient possessory interest in this car to assert the Fourth Amendment." The Supreme Court said, yes, correct, you did. But I think that was a 5-4 decision. So there was kind of a split there. So bottom line, it does actually matter who's asserting or who has the basis to assert the Fourth Amendment. And even if there is an illegal search, an unreasonable search, that evidence may still be introduced if the person who's connected with that evidence did not have a sufficient possessory interest in the place that was searched, if that makes sense. So great question. And yes, it does matter. The identity of the person trying to assert the right can be absolutely outcome determinative.
Not gonna lie, I got a little worried there for a minute about the Russian conversation in your room, but it went well.
They were lovely people, and I got them to leave, but we had a nice conversation.
So let's see if anybody, so we have an online audience and an in-person audience here at the Constitution Center. So anybody in our in-person audience like to offer a question right over here, Jenna, and right there, you can go there first.
You know, and we are from different parts of the world, and most of us are aware about private about privacies inside the houses, but what happens outside the house as movements. I mean, we know that a lot of security agencies rely heavily on tracking phones to find and to analyze activities of suspects. Sometimes with these data, you can confirm if the guy with a phone has been with another high-value target with a phone by the proximity of the two phones. Now, here in the United States, we hear about the Patriot Act. And with the Fourth Amendment and the Patriot Act, how do you mitigate both? Thank you.
Great question.
Yeah, so let me break that into two pieces. You're exactly right that what happens sort of outside of a home is significant and presents some real challenges. I'll just give one example. What would we say about if the government, instead of using a GPS tracker to try to track your movements, they just flew a plane above you with a very powerful, telescopic lens? And the answer to that question seems to be, although that exact case hasn't come up yet, there is a case from 1985 called California v. I think it's Caetano, and that case just involved a police airplane. They had a little Cessna airplane. They were flying it over some houses, looking down to see if people were growing marijuana. Somebody was, and the court said, it was close. I think that was 5-4 or 6-3. Said that because planes are constantly kind of flying, that's a fact of life. There are planes over your house. Then you don't have a reasonable expectation of privacy from planes. But what about a drone? Is a drone different? And we don't have an answer to that question yet, but I think a lot of us, myself included, have a sense that the answer is going to be yes, it is different. Because it's true, like, I live pretty near an airport, and yes, planes are coming over. I can't do anything about that. But somebody starts flying a drone over my house, right? Or flying a drone over my head as I go on about my day, I'm going to take that amiss, right? And so I do think that the fact that you're out in public doesn't give the government sort of free rein to just pretend as if the Fourth Amendment doesn't exist. We're still talking about unreasonable searches and seizures. And I think you can make a strong case that, flying a drone or even a fleet of drones over somebody so that they can never be, out of surveillance range would constitute an unreasonable search. Now, the Patriot Act is somewhat complex. I'm going to try and do justice to it in a very short period of time. But basically, it's a federal statute that deals with or tries to articulate a framework for when the government can perform surveillance, searches, other activities like that of agents of a foreign power. And that's a very precise term. And the Fourth Amendment is actually applies differently to people who are understood to be agents of a foreign power. And so what the Patriot Act tries to do is to find sort of the right statutory framework. And there is a special court called the FISA Court, Foreign Information Surveillance Act Court. I should know this because Foreign Intelligence Surveillance Act Court. My judge I clerked for was the chief judge of this court when I was working for him. And essentially what it is it's like a very secret court where the government can go and get a special kind of warrant to intercept communications and do other kinds of surveillance of activities that they believe involve an agent of a foreign power. And it's not an adversarial court. The person who's being surveilled will probably never know it. And it's not public. We don't have access to the proceedings of this court. And that's caused some criticism. And so Patriot Act was in part an effort to sort of update the procedures for this court, recognize some of the abuses that had happened, and rejigger the balance between the legitimate security needs of the government on the one hand, but also the recognition that just because you say you're trying to, deal with foreign power, espionage, terrorists, whatever it might be, that can't be carte blanche. And we're going to be renegotiating that tension constantly, I think, as time goes by, because we still haven't found the right balance, in my judgment.
Thank you. Very good. Any other questions from the group? No? Jeff, any other questions from your side of the realm?
Well, lots, but I think I'll resist. And do you want to take another round, Curry, or what do you suggest?
I think it's a perfect timing because I know our students have to get back to class or transfer to their next class. So, I mean, I have a million more questions, but we can save them for later because then I can bug Clark afterwards. But I think it was unbelievably powerful. That was a fantastic question that you asked at the end. And a few of our students online were really wondering about the same thing in the Patriot Act as well. So thank you. And I really appreciate how you looked at that internationally as well. So thank you so much, Jeff, for fielding all of our questions on the online team. Students online across the country, thank you. And everybody here at the Constitution Center, thank you. And a big round of applause. You get real applause this time. Not just online applause. Thank you, Clark. As always, fantastic. I appreciate it.
Thank you, Carrie. Thanks, Jeff.
Thank you, everyone. Have a great weekend. Great to see everyone.
Great. Thank you, everyone.
Bye.
It's nice to get real applause.